My name is Mitch McKenzie. Welcome to this gathering. This is the last Greens breakfast briefing for the year, but it's the first in our three-part series on, well, who's got the tome? I'm actually a hard copy man, so I end up going, well, I'll get one. Wow. What I would say is, if you haven't got your own, it is a terrific resource document. When you look at how things have been gathered together, the issues that he has contemplated, the way the report is presented, it is a stunning piece of work. I have had to read it because I'm chairing this gathering. What I thought I might say a couple of things about myself. Embarrassing though it is, solicitor for many years with a smallish firm called Doyle & Kerr, then went across to Tolhurst, Roos and Emerson as a partner there for a few years, and then came to the bar. Been to the bar about 10 years. I get to chair because I'm old, and we have the bright young people who know their stuff, so it's easy for me, and we've got two excellent speakers for you here this morning. I thought before I talk about the speakers, I'll just mention to you, I went off to a dinner last week actually, the Australian Chinese Medical Association, and the reason one of my doctor friends, an ENT surgeon and an anaesthetist, were both there, and they said, come along, because someone's doing a talk on the property market and someone's doing a talk on the share market, and you'll be interested. And I think they think I'm in transition to retirement, maybe so. But the question that I wanted to tell you about was at the end of the night, there'd been graphs about the interest rates, there were graphs about property prices, there was discussion about whether the bubble was a bubble or not a bubble. And the very last question that one of these unfortunate speakers got was somebody who stood up and said, it's all very well to give us the charts, it's already very well to give us those bits and pieces, that's all historical information, we can all gather that anytime we like. We want you to tell us what's going to happen next. Not so easy. So to some extent, that's what today's about. We look at this sort of report that comes in. It's a serious report. It's a lot of time and effort. It's a terrific resource. The government have said, we've got it and we're considering it. And there are some serious recommendations here that need reflection. And they affect a significant part of many practices. And I looked at the list of attendees and I thought, we've got some serious players here who know their way through this jungle, and it's very flattering to have you here to listen to us. There's two more in this series, and today we're specialising on the wills part and the making of wills part. So let's have a quick look at where we're heading. First speaker today is Richard Edmunds. Very, very capable man. You probably do what I do when the time comes. You look at the bar list and do a search, barrister search, and there's the detail set out about Richard. Ran his own practice down in Gippsland, came to the bar in 1988, been around a long time. Clearly a very experienced mediator, has got all the sorts of mediation qualifications and knows his way through that patch. Building disputes practitioner, society, family law bar. The combination between family law and what I might call wills and estates in the whispering jurisdiction is very strong. Somebody once referred to this as family law for the dead because their family's fighting over the bits and pieces that are going on. So Richard's got a background there which is perfect for doing what we're doing. By the same token, so many of these things, if you sit down sensibly with someone who knows their stuff, you can usually get a result without costing an absolute fortune, and the mediation system seems to me to work very, very well in this area. And Richard's got fabulous qualifications in respect to those sorts of areas. He has become something of a specialist on this reform proposal, and I happen to know that he's got a very learned document saying what the proposals were and what was done, and he's presented in all sorts of circumstances. But I said when we were gathering to chat about this, let's see if we can focus on what you want to know as practising solicitors and how you might want to adapt your practice, bearing in mind that we've got recommendations, we've got the government saying they're listening, but we still don't know whether it's going to be pigeonholed or they're going to jump and something's going to happen. So would you please welcome Richard Edmunds to talk on the first topic.
Good morning, and thank you, Mitch, and I thank you even more for the introduction of being bright and young, and anyone at 20 to 8 Wednesday morning. And I also look at Guy Messina, who I went through law school with, know that both of those statements are probably false at this time in the morning. However, very flattered. The report that Mitch showed everyone, excellent resource tool, and if you want to look even further into the resource material that the Law Reform Commission looked at, in each of the 6 areas that it's delivered reports on, it did a consultation paper, and that's the one on succession law relating to wills and will reform. And the reference to case law and the analysis of the history is very, very handy. The terms of reference of the Commission noted that it was to ensure Victorian law operated justly, fairly and in accordance with community expectations in the way the property of a person is dealt with when they died, ensure that the process to resolve disputes for the distribution of property is efficient, effective and accessible, and to identify practical solutions to problems that might be outstanding in Victorian law and practice, and look at the recommendations of what was the National Committee for Uniform Succession Laws, which had been around for a long time and had looked at in all the different states their laws and made recommendations for a national approach. So that was the big picture. In relation to wills, there were 2 specific areas. The Commission was asked to look at whether the current requirements for witnessing wills should be revised to better protect older and vulnerable will makers from undue influence by potential beneficiaries and others, and whether the current provisions that allow the Supreme Court to authorise wills of persons who do not have testamentary capacity to be revised, in other words, statutory wills. So, 2 simple questions. The Commission formulated and published this consultation paper. There were a whole range of issues, a whole range of questions that the Commission threw up, and it obtained a range of reports and submissions from various parties that were heard, I think in March. They were delivered by, I think, the end of March of 2013, and the Commission did its report and tabled it to Parliament on the 15th of October 2013. So the report is just before Parliament, and it's likely, one would expect, that having the in-depth report that the Commission has put before Parliament, that the recommendations are likely to be adopted by Parliament when they eventually get round to dealing with it. I was thinking of heading the paper, "Will Making Almost Got Harder," because when you looked at what was in this report, or this consultation paper, some of the matters that the Commission was looking at were going to impose a great range of new requirements upon practitioners making wills. At the end of the day, and probably what everyone's hanging out for, is to find out, well, what did they recommend? And in relation to will making and undue influence, surprisingly, the recommendation was that the Law Institute prepare best practice guidelines for legal practitioners on detection of undue influence when preparing the will and for prevention of that. And those guidelines cover such matters as the importance of taking detailed instructions from the will maker alone, common risk factors associated with undue influence, the need to keep file notes and make inquiries regarding previous wills. So what did they reject and why did they get there? Some of the things that the Commission looked at, and these are the matters which were of concern to a lot of practitioners and parties that put in submissions. Having a provision that one of the witnesses be a person authorised to take or witness statutory declarations. Have a witness certify the will maker signed the will freely and voluntarily and appeared to have mental capacity necessary to make the will, which is a pretty big step. One of the witnesses to be a medical practitioner who provides an assessment of the will maker's capacity and freedom of will. And I see a few faces sort of scrunching up thinking this is all going to be a bit tricky and a bit difficult and a bit expensive. Witnesses to be aware that they're signing a will, whether you should reintroduce the witness beneficiary rule and have a rule that at least 2 witnesses are not beneficiaries, which suggests that there might be 3 or more witnesses. Everyone who would benefit from failed gifts consent in writing to the gift not failing, or the court being satisfied the will maker knew and approved the gift and that it was made freely and voluntarily. Whether solicitors must decline to act or seek independent advice when an existing client asks them to draft a will for another person, which confers significant benefits on a client. So, for example, the son or daughter drags in mum or dad in a fairly elderly and perhaps fairly obvious state of looking a bit distressed, but being told, I want you to make a will so dad can leave everything to me. And that has happened quite a bit, we see in cases, and the argument's certainly been put forward in affidavits by parties, particularly in Part 4 claims and sometimes in other claims regarding lack of testamentary capacity. And then the question about whether there should be guidelines. So at the end of the day, the recommendation was the Law Institute ought to publish guidelines. The Commission noted that the Law Institute is currently preparing guidelines in relation to testamentary capacity, but hadn't included in it issues relating to undue influence, and has recommended that there be a separate set of guidelines published. The reason that all the above considerations or questions were rejected was essentially it would be too costly, it would be ineffective, it would restrict rather than make easier the making of wills by testators, and there were also problems with the obvious factor that a lot of people make their own wills and don't go to solicitors, so why impose these greater burdens on solicitors making wills when someone can get their will kit and prepare them. The Commission also looked at whether there should be changes in relation to matters regarding the common law relating to testamentary capacity, suspicious circumstances, fraud and forgery, and concluded that in those areas the common law is working well and that there ought to be no legislative changes in relation to that. So what sort of guidelines are you going to expect, which is probably the most important question, and whether you get ahead of the field by having your own guidelines to look at or work from if you suspect that there might be any undue influence being imposed upon a party who's going to make a will. The Law Institute's already published guidelines that I just mentioned that are useful to look at. They're on the Law Institute website, published in March of 2013. One's a guide for beneficiaries, one's a guide for executors, so you should expect some sort of colourful publication in the future in relation to testamentary capacity and undue influence. But where would the Law Institute look to prepare these guidelines? And the Commission has made some recommendations. The existing guidelines are some from the British Columbia Law Institute, titled Recommended Practices for Wills Practitioners Relating to Potential Undue Influence. A interesting publication. It's got a range of tables and charts, and particularly at the end of it, a checklist of recommended practices, which I've printed up and attached to the paper that's with the materials that you've got. There are other publications that the Commission has noted, 2 of them in particular, Nick O'Neill and Carmel Pessa, Capacity and the Law, Sydney University Press publication, that's on the Osley site, and Kenneth Schulman, and others, an assessment of testamentary capacity and vulnerability to undue influence, 2007 publication in the American Journal of Psychiatry. The Commission also took into account submissions from various interested bodies. There were submissions from Law Institute, some independent law firms, the Property and Probate section of the Commercial Bar, which I was involved with, co-authored a submission. There were submissions from state trustees and equity trustees and I think from the Salvation Army and a whole range of other independent lawyers and barristers. And some of the matters that leapt out that should be included in guidelines to look at were, at the top of the list, the importance of taking instructions from a will maker alone. Not to have, in other words, the rather interested party driving the ultimate benefit to them, sitting next to mum or dad pushing the instructions. To prepare a list of common characteristics on how persons might be subject to undue influence and how they would physically present. Common warning signs of undue influence, such as a sudden change in a bequest, particularly where there'd been a series of wills that in the past had left property to certain beneficiaries, and then all of a sudden, out of the blue, a unknown carer or some other strange friend who has been not known to any of the other close family members suddenly benefits totally. The role of interpreters who accompany will makers, importance of making inquiries about previous wills, and the need to retain detailed file notes. Now, this checklist, if I can just run through some of the matters in it, the important matters, you've got 9 recommendations for how to deal with or check off matters. Again, this is from the British Columbia Law Institute list. So they start off with interviewing the will maker alone, asking non-leading open-ended questions to determine factors operating on a will maker's mind. And they give examples, and these are some of the examples, and if you want more detailed examples, you can always go to the British Columbia Law Institute site and just have a look at their full publication. But questions like, why did you decide to divide your estate this way? What's the importance of you deciding to divide your estate this way? Why did you choose this person as an executor? So trying to flesh out, rather than just take the instructions, flesh out the reasons and see if they give coherent and logical reasons when they give those instructions. Explore whether there's a relationship between the will maker and the person who may be exerting undue influence of dependency, domination, or special confidence or trust. And then, again, a series of suggested questions to ask, and they're helpful to look at and to tick off. Explore whether the will maker is a victim of abuse or neglect in other contexts, and sort of also flagged with a sort of a warning as to being tactful and aware about how you ask these questions. But it may be that someone has hurt, threatened, or put someone in a position of fear that they might lose care. Quite often you see cases, I'm sure many here have seen cases where people have said they only made the will because mum or dad were told, if you didn't leave it to me, the carer, I'll walk out on you and you're left alone, there's no one to care for you, and your children, they're living interstate and they can't care for you. Look at relevant information from third parties, and when possible, if the will maker consents, of course. Obtain medical assessment of mental capacity, with a notation that mental capacity to make a will is ultimately a legal test. And bear in mind, one particular case, one of Vashallo and Cantor, in about 2006, I think, the Court of Appeal looked at the reality that persons who may have in this case dementia, can move in and out of periods of lucid moments, and there may well be a very lucid moment when you're getting instructions, and maybe before that, a month before or a month after, that will make it may not be showing those lucid moments and may not have testamentary capacity. So the question is to look at the big picture and take some very detailed notes. We've got a list of red flags. Now these are really handy to look at, to go through, and they've even got their little boxes beside each, yes, no, or not applicable, but whether the willmaker invests significant trust and confidence in a person who's a beneficiary is connected with a beneficiary, giving examples such as lawyers, doctors, clergy, financial advisors, accountants, etc., carers. Isolation of the willmaker resulting in dependence on another for physical, emotional or financial needs. Physical, psychological and behavioural characteristics of a willmaker, and these are handy to look at because they give examples and in more detail in the publication, but dependence on a beneficiary for sight, hearing, mobility, speech, illness or illiteracy, signs of self-neglect or neglect, whether the person appears in a state of shock, non-specific factors such as loneliness, sexual bargaining, end-of-life issues, cultural influences, impaired mental functioning from a psychiatric condition or non-psychiatric cause, and then they give a whole range of examples. And in relation to circumstances related to the making of the will, they give examples such as unusual gifts or sudden changes in gifts that are being made, frequent changes in instructions of a testator, changing the will every 2 or 3 months and changing people who benefit insignificantly. Whether a third party attends and initiates all of the instructions. Spouses, there's a comment whether a joint retainer in a situation where you have one spouse giving all the instructions and the other remains silent. It might happen a lot, but it's one of the red flags that they identify. And recent death of a family member. Then they give examples of characteristics of what they call the influencer, or as I think Terry calls them, the driver. Overly helpful, giving you all the instructions, and this is what dear old fellow wants to do, and insists on being present during the interview. Contacts the solicitor persistently. Have you done that will yet? They're really anxious. They want that will done. They really want to leave it to me. Person known to have, to the practitioner, to have a history of abuse or violence. You might have a family member who has a drug habit or just a history of violence towards not only members of the public but particularly to their parents. A lot of elder abuse might be obvious to. If a practitioner observes negative or controlling attitude to the will maker by the person present, or if the practitioner is aware the influencer themselves is in a difficult financial position and has suddenly dragged someone in to make a will to benefit them. And then of course there's the gut feeling of the practitioner, the body language, if the influencer is rude to staff or overly solicitous. So a whole range of helpful tick-offs that you may find included in a new set of guidelines, and if you've got anyone who comes in your office that exhibits any of these signs, it might be handy just to go through this, tick it off, and if ever the case comes up in time to come that there's a claim that there was undue influence applied, well, you have those detailed notes. So that's in relation to undue influence by way of guidelines. There's a second recommendation, and that was in relation to equitable undue influence. I'll read the recommendation first and then go through what equitable undue influence is, because I had to read it a couple of times just to see the comparison. The recommendation is 4 years after legislation comes into effect, the Attorney General should prepare a report and look at what the operation of the law in British Columbia is that imports an equitable doctrine of undue influence and look at whether a similar doctrine should be applied in Victoria. There's no major change to the law of undue influence recommended by the Commission. It had noted that it's been really hard to prove, really hard. There's been very few cases that have succeeded. In fact, so hard that the Commission noted that 3 successful cases back in the 1880s. Then there was a case most have probably heard of Nicholson and Knaggs in Victoria. And since then, in 3 separate jurisdictions, 3 successful claims and also 1 in the United Kingdom. So the Commission has thought, well, let's just see how things sit in the next few years and see how, since Nicholson and Knaggs, the court's approach undue influence and whether or not that case actually makes it somewhat easier. The Commission suspects that the tests propounded in Nicholson and Knaggs might make it somewhat easier to prove undue influence. Equitable undue influence is a bit different than the probate undue influence doctrines in that it relates to transactions occurring during a person's lifetime and allows a lifetime gift or transaction to be set aside when a person is in a position of undue influence over the donor, unless the person who benefits can satisfy the court no undue influence was used. And it gives examples of categories such as parent and minor child, doctor and patient, legal practitioner and client, where there can be a presumed case of undue influence, or a case of a relationship that is one of ascendancy, power of domination, and dependence and subjection. In equitable undue influence, there's no need for a weaker party to show any wrongful act or threat, or even that the stronger party did dominate the weaker party. So you have these categories that presume undue influence, and then the burden is on the person benefiting to dispose of it. And even where the person who's in the weaker position is agreeable to the transaction, there still may be that case of presumed undue influence that then the benefiting party has to set aside the burden. The legislation in British Columbia I've noted in the commentary, and that is the legislation that the Commission is suggesting be reviewed in 4 years' time to see how it works and how the common law is working. The other area that, in relation to wills, the Commission looked at was statutory wills. 2 issues in relation to that. One was that the recommendation was that the Wills Act should expressly provide that the court can order separate representation for a person on whose behalf a statutory will application is made. And that was essentially because although a person who can be affected by an application for a statutory will can be given notice of the application, there's no actual need for them currently to be represented or even appear at court. And in many cases that might be logical because they might never have had any capacity. But the Commission noted that there are examples of where an incapacitated person may have the benefit of being represented. And that is, for example, in relation to expressing what limited view they may have, and also in relation to costs of applications, whether or not there ought to be a defence on behalf of or application on behalf of the person who the statutory will is sought to be made as to who should pay the cost of that application. Commission looked at whether VCAT should hear these matters or they should be heard on the papers and rejected both submissions. One on the basis that VCAT is probably not going to be any quicker or any more cost effective than in the Supreme Court. And the Supreme Court itself recommended that in relation to hearing it on the papers, that if submissions were simply put in on papers, all the material the court might want to address or have discussed might not be before it, and it's better to have the application before a judge. Then there was a question of costs. Sorry, there was a, thank you. Question of whether an application for a statutory rule should be made in 2 stages or 1. Currently you've got to get leave to make an application, then you make the application. But in practice, the leave application and the application are rolled up into one, so it's just suggested an amendment there. In relation to costs of statutory rules, there was a question, should there be a change in relation to the law? Should there be a statutory ruling as to who pays the costs of those applications? And essentially the Commission said leave it in the discretion of the court. There have only been something like, I think it was 15 or 19 statutory rule cases since the legislation was amended, of which a number of cost orders were made against the estate. In some cases, cost orders were made against the person making the application. The court has exercised its discretion, and there should be no impediment in it doing so. So there's a précis of the areas relating to wills, and Terry will shortly give you a rundown of what happens after the will's made and the executor seeks to get his commission. Thank you.
Thank you, Richard. Let's just get the procedure set out. What I'm proposing is that we take a break, 10 minutes, grab a coffee, help yourself out there, mingle. There's some terrific networking going on, I've already noticed that.